各位长官与现场的贵宾
Distinguished guests, ladies and gentlemen, good morning. Welcome to the 2026 Internet Communications Governance Forum and taking part in this important multi-stakeholder dialogue. We will now begin our first session, titled Seeking Common Values in Global Internet Governance. The moderator for this session is Commissioner Wang Yihui of the National Communications Commission. Please welcome Commissioner Wang. We will now invite our honored guests to join us on stage.
Join us on stage. First, please welcome Benoit Lute, Commissioner of Arcom. Welcome, Mr. Lute. Please enjoy us. 接着，我们欢迎元智大学。
Next, we would like to welcome Associate Professor Ye Zhiliang from Yuanzhi University.
Next, please welcome Samaya Anju, Policy and Communication Associate at Global Network Initiative. Mrs. Anju, please join us on stage. 接下来我们
Next, please welcome Ms. Liao Yilin, Senior Corporate Counsel of Corporate External and Legal Affairs at Microsoft Taiwan. Finally, please welcome Ms. Zheng Genying, Supervisor of the Taiwan Internet and E-Commerce Association. We will now handle the floor to the Commissioner Wang today. Ladies and gentlemen, good morning. I'm from the National Communications Commission. So welcome to the forum today, the 2026 Internet Communications Governance Forum, as we're seeing rapid changes across the Internet landscape. These years, we've seen a lot of changes as well. During the keynote speeches in the first session in the morning, we've heard about the development of AI technology. Of course, these technological advancements have also ushered in new changes of our lives and, of course, the Internet landscape. Of course, this will also allow us to think about how we are going to further implement the Internet and to better the improvement of the system. So we will follow the dialogue this morning, and we are going to discuss how we can seek the common values in global Internet governance. So with the speakers here today, we hope that we can explore some of the development and solutions. And I hope that the dialogue today will give us the opportunity to offer the common values across different boards. Today, we are very honored to have 5 different guests here. So allow me to introduce them. The first is, of course, Commissioner Benoit Lute from Arcom. So he will talk about the GSA from the European Union and also its framework. Right here, we also have Associate Professor Ye Zhiliang from Yuanzhi University. So he will talk about the fragmentation and how we can further implement the system across the perspectives of different stakeholders. And next, we have Ms. Samaya Anju from Global Network Initiative. She will talk about different legal frameworks across different countries and, of course, the impact of multilateralism. The fourth speaker is Ms. Emma Liao from Microsoft Taiwan. She will share the perspectives of enterprises, how we can go about Internet governance. Last but not least, we have Ms. Zheng Genying, the supervisor of Taiwan Internet and E-Commerce Association. Of course, she will share with us some of the practical perspective. Of course, the industry, how they are evolving with the trend here. So I would like to give them a round of applause, and I would like to please welcome the first speaker, Benoit Lute, please.
Well, thank you very much to the NCC for organizing this incredible conference. I'm very happy to be here and to learn from the Asian experience, from the Taiwanese experience, and to share our experience in Europe. I would like maybe to cover quickly the the basics of the fundamentals of the dynamics of the DSA, the European Digital Services Act. I guess, as you know, like in many parts of the world, we had a vibrant digital industry delivering innovative services. Sorry. And but we realized that, of course, we love the innovations, the new services, but we had also to deal with the side effect of what we call information disorders. And that the policy dialogues between the governments, the civil society, even the justice system and the platform in a way was not working, because digital services are not material. You cannot observe them. And the digital services are individualized, so it's very difficult to observe what are really delivering to everybody. And that's what was an obstacle to the development of the industry. So that's really the aim of the Digital Services Act, is to reestablish the capacity of all stakeholders to work together, to be and to convince ourselves that the platform are part of the solution to issues like fraud, like hate speech, like scams, and to make sure that we could re-establish a dialogue and a partnership between the industry and all the stakeholders involved. We realized that the thing which was missing was this capacity to give trust to the statement made by the industry players. We would have a burst of hate speech, for example, in Germany in 2017, or disinformation in France 2017 also. And it was difficult for people to put trust and say, okay, but the platform are telling us something, why should we believe them? So basically the framework was designed just to fix that issue. So with two strong requirements. One is a duty of care, which is basically saying, well, to the industry, you have been implementing trust and safety. It was a good business practice. Now it's a legal requirement. We are not telling them what to do, but we are telling them, you have to do it. You have to take care of your clients. And because it's a legal requirement, you are requested to report legally. So suddenly the transparency report have more values because they are legally requested. And the transparency requirement is also extremely important. It's not asking them to release trade secret. We don't ask them to make public the codes of their algorithm, which are, of course, at the heart of their innovation and should be protected. But the transparency requirements, it tells them, well, if you put in your algorithm an intent, it should be made public. Think of a social network. If a social network decides that its algorithm should increase the visibility of the issue of climate change, that's a good thing, but we should know it. How they are doing it with the algorithm is a trade secret. We are fine to keep it secret, but we should know what they are doing, what is the intent of the action, what they are doing in their content moderation, so that it then can be a discussion. And as you fix with this transparency requirement, this issue that the industry by itself lack any credibility, suddenly it empowers everybody to enter in very active discussion. To give you an example how we apply it to hate speech, because we are seeing from time to time that we have bursts on hate speech targeting specific group. Thanks to this framework, we are now able to organize what we call the Hate Speech Observatory, which is chaired by the regulator. In fact, co-chair with the justice system, we have a public prosecutor on hate speech, where the platforms are here, seated in the forum. All the NGOs are who are engaged on those issues, who are part of the human rights movement, who are fighting specific hate speech, or also fighting to protect the freedom of speech, come to this forum, and we can have a regular discussion on how we are collectively dealing with those issues. And the platform can explain how they are implementing the content moderation policy, answer all the question. We can have a dialogue with the NGOs to discuss, say, what is the responsibility of the platform, which in some cases should implement a notice and takedown system. In some extreme cases may have to close down some accounts of repeated offenders. What is the responsibility of the justice? Because it's one thing to go to take down the content, but in some cases you want to take the authors to court. And thanks to the DSA, thanks to the fact that we have the transparency requirement, we have now new dynamics which allow us to tackle collectively new issues while protecting also at the same time the capacity of innovation of the industry. I gave the example of hate speech, but we also have the same thing now on public health issues, where we are seeing a new obstacle for public health policies, let's say on eating disorders, to fight eating disorders, where we can open now constructive discussion with everybody. We have that on intellectual property infringement, and we are slowly expanding it to all issues, all information disorders that can exist in the digital environment, and where we want a greater accountability of the platform. And thanks to this legal framework, to this very basic requirement, duty of care and transparency, we are slowly learning to work together and to make the digital space a sustainable and welcome places. Thank you very much.
Okay.
Thank you very much. I would like to thank Commissioner Benoit for his very thoughtful insights. Next, I would like to invite our second speaker, Professor Ye, to share with us his presentation. Thank you very much. Yes, please allow me to use Chinese in my presentation. In my PowerPoint, actually I have an English version, but I will try to speak in Chinese. My topic today is basically to find the common value of a platform. Because today we are seeing every balance of the digital ecosystem. We have very large platforms, and also there's an increased awareness on the protection of the environment and also the users. The internet has evolved into the commercial domain. It started in 1996. John Kerry Vogel mentioned that we want a free and open internet. However, after 30 years, we see very rapid changes in the internet. There are many countries who argue for digital sovereignty and sovereignty of the internet. Therefore, we see that there is a change from one that is free and open to one that is very fragmented because of technology, because of firewalls. And this trend is becoming more evident. After the emergence of AI, we see that there are many huge AI platforms. They are taking time from the users and also taking efforts from the users. As a regulatory body, the government has to do something. The government should think about ways to make the large platforms more transparent. Because if we look at AI, we look at its algorithm or its operations or look its users, our government of course wants AI to be more transparent. With the emergence of the internet, in the past we talk about governance. We focus on discussions among different parties. However, today we have one or a few very huge platforms. Therefore, now we hope that we can have the opportunity to revise or to encourage the large platforms to become more transparent. In the past, governance and safety of the internet is focused on the stability of the hardware. However, today, we see the emergence of deepfake technology and also other automated services that is able to produce fake information. It has caused a very huge trouble among the end users. We talk about stability of the hardware to the realness of the information content. Therefore, we need to establish trust within the ecosystem. There are many ways we can do this. One way is to use identity verification or to use more stringent privacy standards. There are many methods, and there are people talking about the different ways by which we can safeguard the users. As a regulator, the government used to be an onlooker. However, today, the government has become more proactive. It has become a overseer, and it also has become a promoter. There are so many parties involved in the operations of the internet. Therefore, it is important to arrive at a consensus with the different stakeholders. In some countries, they have started to implement the regulatory sandbox. For instance, in the past, the government has provided specific experimental sites for use as sandbox, so that businesses can make use of trial and error to establish order within the industry. I believe that this sandbox concept can be promoted into many other areas, such as AI. The establishment of digital trust is to enable users to have more confidence to use AI and other forms of internet services. Digital trust starts actually from people. It should be human-centric. Government can formulate legislation, or platforms can also find ways to have a mutual agreement with the users. However, it all leads down to people, which is the end users. And one thing that we cannot ignore is basic human rights. Therefore, it is important to promote transparency of the platforms. The government is also one of the promoters of public-private partnership. Today, we are affected by geopolitics. In Taiwan, we face many threats, as well as other conflicts. In the past, government acted as a bystander in the internet governance. However, the government now should play the role of a promoter of public-private partnership. In so doing, the government will be able to safeguard the safety use of the internet. Another very important factor that we need to consider is the participation of all stakeholders. This is something that we should let continue, and I truly believe that in face of the dominance of very huge platforms, for instance, we have technology communities or civil societies should be able to make a stand. We also mentioned earlier that legislation also provides a system of check. There are also many soft law that we have seen in recent years. I'd like to especially mention that discussion on the internet should also involve other areas. For instance, the Global South. The responsibility of a platform is very important. And finally, I'd like to move to this slide. Whether it is top-down or bottom-up, the main task is to ensure safety and resilience. And lastly, we want to talk about our common values. With this very flexible framework, we will be able to forge a consensus in the future. Thank you. Thank you very much, Professor Ye. Thank you for your very insightful presentation. Next, I would like to invite our third speaker, Samaya from GNI.
Okay. I hope I'm audible. Yes. Thank you, Commissioner Wang, and hello, everyone. It's really nice to be back in Taiwan. I also want to take a moment to thank the organizers and NCC for having this discussion today. I work for the Global Network Initiative, which many of you are familiar with, but just by way of a quick introduction, GNI is a multi-stakeholder organization. We work focusing on freedom of expression and privacy in the technology sector and have a membership of more than 125 civil society organizations, tech companies, which includes social media companies, infrastructure providers, telcos, and I want to acknowledge Microsoft here with me on the panel as one of GNI's members. We also have academics and investors within our membership, and GNI works across several different pillars in order to sort of advance its missions. One is policy advocacy, which I lead. There is cross-sector learning within GNI's internal membership. The heart of GNI's work, which also led to the founding of the organization in 2008, is the independent GNI assessment process, which is human rights due diligence that our member companies voluntarily attend within GNI, and finally we have the fourth pillar of our work, which is because GNI is it's a multi-stakeholder space, which means a lot of in order to preserve the trust that is required for stakeholder groups to openly and transparently communicate with each other. A lot of conversations happen internally and confidentially, but we do take learnings from these conversations and contribute them to global and regional processes through collaborations with UN bodies, etc. And I mention this because it's really nice to be here today in a multi-stakeholder space, and a space that is multi-stakeholder friendly, which is not extremely common. We have, I'm not gonna, the panel's about sort of common values within internet or digital governance, which is, and these are difficult shoes to fill. So I will be speaking somewhat in broad strokes, but I'm happy to sort of converse later on specifics with folks individually. So one of the primary trends that I will be speaking to today is the scale of global diffusion of regulatory norms. One of the most significant developments in recent years has been the emergence of mandatory human rights due diligence under the law, most notably through the European Union's Digital Services Act, which Benoit helpfully explained. And now we're seeing versions of these frameworks spreading globally as governments, primarily in the majority world, increasingly transpose complex regulations or regulatory templates from other jurisdictions into their own. Now, we're also seeing such regulatory expansion in online and child safety, with the UK and Australia playing leading roles, a rise in cybercrime legislation, which is accelerated in part by the UN Cybercrime Convention that came to play last year in Hanoi. And there is, of course, the continued emergence of data protection regimes and national AI governance strategies. In many ways, this is both normal and necessary. Governments need to respond to real societal harms. However, one of the recurring patterns that we keep seeing is that despite adopting increasingly sophisticated frameworks in many countries, the primary or default response to these challenges is to moderate content. Now, there are variations of these content-specific strategies. There are, in data protection contexts, many governments continue to equate data localization as the primary driver for protection or sort of a solution mechanism. In cybercrime legislation, we have overly broad definitions that sort of create an enabling environment for arbitrary enforcement. And part of the challenge, of course, that arise from these inconsistencies is the mismatch in regulatory capacities or institutional design and implementation realities, of course. But the other thing that is less sort of deliberated on is the when specific regulations or regulatory models are upheld as the gold standard, and it's a helpful basis for other countries. But within GNI, we've noticed how this can be increasingly context, we're missing the context specificity, and sort of regulators or when governments discuss laws within a specific context before they transpose into other jurisdictions, there is very huge gaps in global majority participation. There are gaps in regulatory and civil society capacities. And the other sort of challenge that we have is the multilateralism coming at the cost of multi-stakeholderism. We recently had a positive development when the UN IGF received a permanent mandate under the WSIS+20 review. However, if we look at other spaces, such as the January ad hoc committee discussions on the rules of procedure for the UN Cybercrime Convention, provisions that relate to multi-stakeholder participation face some of the strongest pushback. And this rise in multilateralism that has, there are implications beyond civil society and the private sectors. It creates barriers for UN human rights bodies and special procedure and bodies with special procedure mandates to meaningfully engage in these governance processes. I will come back in my later input to the challenge, even when governments attempt to be inclusive, the challenges that we as an organization and our members have faced in terms of engaging in consultation processes. But I think the key sort of against this backdrop, the key message or the common value that I would leave behind here is the importance of kind of having to continue these discussions. I'm sorry, I feel a little, but thank you.
OK， 谢谢Samantha 那因为我们等一下还有一些时间，我们如果可以再继续。那现
If we have more time, we will allow more dialogue on this. Next, we would like to welcome Ms. Emma Liao from Microsoft Taiwan. Good morning. I am from Microsoft Taiwan. I am the Senior Corporate Counsel at Microsoft Taiwan. So I'm here to share Microsoft perspective. So what I would like to share with you is some of the trends that Microsoft has observed in terms of internet trends. Now, compared with the past internet governance pillars, so basically it was the discretionary self-control, and now we are seeing that the government is issuing a lot of standards and regulations and policies for us to really abide by. So a lot of the legal frameworks have been established by the government. The reason for that is because of the voluntarily policy or the practice does not meet the real-world challenges right now. Also, the public policies now have shifted their focus. For example, in terms of internet governance, we are seeing a lot of focus has been shifted towards AI, data security, and national security. That is why we are seeing that in different jurisdictions, they have different approaches to address these issues. Even though many countries embrace the values of democracy and human rights, still, there's a huge gap between how different countries approach these issues and different policies and regulations. So you can see that different legal perspectives have been implemented. So now we are seeing a high level of fragmentation, and that of course will compromise the rights of the end users and of course the security of the internet. That will of course hinder the free and open environment on the internet. We know that the internet facilitates the spread of thoughts and of course freedom of expressions. So you will also see a lot of challenges in terms of legal compliance because of that. Another trend that we have observed is that the governance landscape has seen a lot of convergence. For example, internet governance now has involved AI, data security, and national security as well. And of course, that will allow us to see more promising governance approach. But in some jurisdictions, they have implemented fragmented approach. This will hinder the freedom and interoperability as well as the openness of the internet. So in the past, the regulatory focus was on a certain area, but now it has elevated to the system level. For example, the resilience building and infrastructure management, as well as the management of supply chain. Of course, that all echoes back to what we're seeing right now. You have the convergence of the governance in different areas, for example, data security, national security, and all of the things that I just mentioned. So the trend on the internet that we are seeing right now is that we should also think about how we should launch a new regulatory framework. If we want to secure the internet, what's the justification? For example, data localization or the transmission, cross-border transmission of data, or the internet connection or the human connection. All of these need to be catered to. We do not want to compromise any of these. So Microsoft Taiwan, of course, would like to see that we can have the governance over these issues, and we should embrace a core value that is free, open, interoperable internet landscape. The legal compliance, of course, should also be taken care of, and of course, we should also take care of the proportionality and other areas as well. Now, on the role of the government, of course, we can see that the government plays a major role. They can define what's legal or not, how we can protect our citizens. However, what we are seeing is that there's a challenge for the government right now when they are trying to implement a regulatory content, for example, a legal content. This actually constitute a challenge. Of course, this is a well-intentioned policy, but this is a challenge for the platforms because they will ask the platforms, the government will ask the platforms to take a preemptive approach. For example, the government would like the platform to define what they will do, but that also is a problem because different countries have different definition. So if we want to really take care of these issues, if we want to embrace human rights, these will be essential. So I think that we should have a elected agency by the people to really launch these policies. So these should be separated. You should not delegate the government to do this. For example, if we let the regulators to implement the policies that they formulated, of course, this is not a law and regulation, but it will hinder the freedom of speech, and you will see that the power has been centralized on a certain government or agency. So we hope that the administrators should also abide by the power of the separation of powers, and of course the due process, and they should protect the access of data and everything. Now we have experts from the GNI, so of course we would like to share our perspective on multi-stakeholders. Microsoft is very thankful to the UN General Assembly, the WSI. In this document, it reasserts that we have adopted a model for the data, and of course they have extended the authorization on the IGF to 2035. All of this shows that the internet governance across the world has involved multi-stakeholders, and it has been validated. And we believe that all of you here are the experts, so I will not dwell on this, but I do think that different stakeholders will have different roles to play. We talked about the government, and of course, the civil society and the academia will also play the role because they will provide valuable suggestions. For example, civil society will talk about human rights and also the civil rights. I think that they have offered a lot of suggestions, and they can also provide the user experience that we would like to seek. And of course, the industry can also provide suggestions for technological advancements. That is why we say that multi-stakeholders are important. And we believe that this approach is actually highly recommendable because it will reflect the real world scenarios of the world, because we will be able to hear the experience from different stakeholders. We need different stakeholders' opinions and perspectives to help us reach the internet governance. So that is the end of my presentation here. Thank you.
Thank you. Thank you very much. Next, I'd like to invite Ms. Chen. Yes, thank you very much. I am from the Taiwan Internet and E-commerce Association. TIA is the short name for our association. My task today is simpler because the speakers before me talk about governance from a global perspective. However, I'm here to talk about an example that actually happened to one of our members, and this example actually pertains to governance. TIA was created in 2012. We have members from Taiwan and also from other countries. Microsoft is also a very important member. We act as a bridge between the government and industry. With regards to governance, we understand that it is a very important topic, and it is also very widely discussed in Taiwan. I have taken part in many activities, and I found that we have been talking about governance for quite some time. Many of the business associations and the competent authorities in Europe have started to focus on scams and frauds. However, in Asia, I believe that we are slightly ahead because we have been aware of this phenomenon for quite some time. Over the internet, sometimes there might be activities that may be unlawful. But for our association, most of the times we found that there are products that are unlawful. For instance, in an e-commerce platform, some of the products are being sold that do not comply with regulations. For instance, in Taiwan, people in Taiwan like to bring cosmetics from Japan and sell them online. However, there are many regulations that will apply. Some of the sellers, for instance, are unaware of these regulations, and they may in fact infringe the law. And because of this, this has become a very important issue because many of the digital platforms are a way by which people interact with one another. We buy and sell products, we teach using the platforms, and also news is also disseminated through these platforms. Therefore, the digital platforms are very important. It is thus important to manage and to oversee the accuracy of the contents of the platform. The issue today is it's not whether to regulate, but how to regulate. In order to deal with the challenges, many of the countries try to strengthen the responsibility of the platforms. However, if the legislation is too vague or ambiguous, sometimes it will become counterproductive. Some of the legal information may be deleted, and the result will not be satisfactory, and it will also infringe upon the freedom of speech. It will also hinder innovation and other activities. Next, I would like to give you an example in Taiwan. Taiwan is a place that forbids electronic cigarettes. It is unlike in Europe where everybody actually smokes these e-cigarettes. Because in Taiwan it is totally banned, and this also applies to the internet and also to cyberspace. One of our members is a social platform. They are able to express their opinions on the platforms. There are people discussing about e-cigarette, whether it will affect health or whether it is easy to use. And the competent authority will see this and then will forbid this kind of expressions over the internet. Therefore, the competent authority will ask our member to delete any messages that includes the word electronic cigarettes. However, in Taiwan, there are still some sellers who might unlawfully sell e-cigarettes. Because this is unlawful in Taiwan, therefore people will not explicitly say that I will sell this product. So they will use a code instead of the name e-cigarette. So some sellers on the internet, they use the name a bubble tea as a code name for e-cigarettes. There's a platform that once that was very popular because the platform actually says that it sells bubble tea, which is a code name for e-cigarettes. Another code name is candies. Many of the sellers use candies. And as a result, there was one very many prominent buyer who used the keyword candy to search on the internet, and he saw that a seller was selling candies. So using candy as a keyword for search, this buyer actually found sellers of e-cigarettes. So these are some of the ways by which sellers use to circumvent the law. Therefore, businesses, when they receive notice from the competent authority, they need to take down the ads because this is illegal. However, they will still be fined, even if the ad or the information has been taken down. This is one of the issues that we have been dealing with over the past 2 years. The NCC is very familiar with the internet and also the management of internet contents. We often hear that NCC currently is using soft law as well as dialogue with the businesses in order to deal with some problems. We know that in order to solve these problems, the NCC also formulated some self-discipline guidelines and actually held dialogues with the industries. I think this is a very good model, and we still see many members receiving fines for the sale of e-cigarettes. I think what I want to say is that we need to be very clear in what we are banning, because if the law is very ambiguous, sometimes it will become counterproductive. It will also undermine freedom of speech, and it will it will not benefit any parties concerned. Therefore, our association hopes that there will be a clear demarcation line saying which is lawful, which is unlawful. We hope that in the future, the competent authorities in Taiwan can give us a clearer direction for businesses to follow, so that we will be able to prevent some of the instances that have happened in the past. Thank you very much. I would like to thank Supervisor Cheng. She used a very clear example to explain to us the challenges that we face currently. Next, I would like to proceed to our Q&A session. I have questions for each of our speakers. First, I would like to ask Benoit. We know that DSA has legislated the responsibilities of a platform from the perspective of oversight. In addition to DSA, it also needs to be able to work together with the judiciary. So may I know what is the area of your cooperation? Thank you very much.
Well, thank you very much. I guess we have discovered, in fact, that we needed the judiciary to be in the picture for several reasons. One is that because the DSA is not about content regulation, the regulators have no power over content, but still some content are illegal, so we need the judiciary to do their work, and in some cases to remind people that there is some limits set by the law to free speech, that some speech can be harmful. And the judiciary has a need for the regulators, because we have discovered that over time, because the digital industry is global, some platforms do not want to work with the judiciary in various countries. So I guess at some point that's how the discussion started with a platform named Telegram, which was not answering any request from the judiciary to provide information, to take down some content. So the judiciary branch in France with the Court of Paris issued a warrant, and if you remember 2 years ago, they arrested Pavel Durov, the creators of Telegram, which was at least from our point of view, I don't know how is it from an Asian point of view, a wake-up call on the fact that the judiciary has to play a role, and that if innovation is always welcome in our countries, but we just at least request that the rule of law be respected, and you have to subject to a request from a judge if you are requested to make a deposition. And it started a collaboration on broader issues, because we realize, in fact, that the judiciary needs to have access to expertise to understand how the digital world function. And that's one of the byproducts, in a way, of the Digital Services Act, because we request from platform to provide access to data to academics. We allow academics from all universities to produce knowledge, a greater understanding of the industry, and this greater understanding is also something which is needed by the judiciary. We continue to work like that, and now, as mentioned it quickly, on the hate speech example, in some cases you have to decide whether you want to go to take down the content, because you know the author is hiding somewhere in the world and you will never catch him, even with the best judiciary. In other cases, on the contrary, you want to give the priority to go after the individual, so that's why we have this discussion with interested parties, all stakeholders, on where are the priorities, where should we put collective emphasis. And we are slowly building on this collaboration, including on the fact that we know that in this industry, in some cases, individuals play a leading role. I gave the example of Pavel Durov. You may have in mind that we have X was created and is really leaded now. No, sorry. It was bought by Elon Musk and is leaded now really by Elon Musk. And we have a lot of questions on on X operation, and he was requested to appear in court in Paris. He has not appeared in court in Paris, so now our public prosecutor has designated 3 independent judges who are going to follow on the X cases, and possibly will issue a warrant for this individual. And we realize when you are reached by tens of billions, hundreds of billions, maybe you don't care whether you're going to get a fine for 1 billion euro, but you do care if you are restricted in where you can travel, and so it's part of the story. I guess we learned it also from history in the 19th century. When you're dealing with huge companies, trust, you need to have all instruments of public policies, and at the end we share the same goal. We are really trying to increase the accountability of those companies and increase the accountabilities of the individuals who are running those companies and who are taking the decision, who are leading those companies. So I guess we are realizing now that we have to have a better understanding, a better collaboration between the regulators and the judiciary. I always give the example when a plane crashes. It's terrible. You have 100 people who can die. You have 2 processes which start. One is a legal process with the judiciary leading to establish the criminal, the civil liability of the constructor of the airplane, of the airline company which operated the plane, of the crew who operated the plane, of the traffic control, and you have the same process with the regulator. But trying to understand what took place to change the rule, maybe to avoid future crash. Well, it's the same thing here. We really need to have a public policy going hand in hand, both one leg on the judiciary, one leg on regulation. And we do expect to get greater accountability at the end. A last issue that maybe I wanted to mention on this issue of liability and the division of labor between the regulator and the judiciary is this limited liability scheme that we are all now familiar with. We have it in Europe. It comes from the US, from Section 230. You have a limited liability for regarding content which are user-generated content. I think we have to fully to revisit the scheme, not to change it, but to really understand the consequences, because we are always surprised that people tend to not to send that many cases to court. In fact, it's one thing to say that you are not responsible for the content which are generated by the users, but still you are liable for your algorithm. If your algorithm is really the one which is exploding the dissemination of a specific content, you have to take responsibility for your algorithm. So in fact, it's another place where we are trying to open discussion with the judiciary and to get people to really understand the full extent of the limited liability, but nothing more, and recognize that you can also engage in some cases the liability of a platform which de facto do not keep under control its power to amplify specific content. And that's really the power of the platform. Last thing that maybe you have heard of, I guess it's a recent decision from the Brazilian Supreme Court, which is challenging the limited liability to the extent that it's applied to advertisements. And they are making a difference between the limited liability for user-generated content, which I fully recognize, but says that maybe we should revisit when it's being applied to advertisement, because when you advertisement, you are being paid to disseminate a specific content, and maybe you should take a full liability for such content. It's a question that we are raising also in France for policymakers. Thank you very much.
Thank you. Thank you, Bernard, for your sharing on how the regulators view the responsibilities of the platforms and how, in practice, we can collaborate with other parties. And now I would like to ask Professor Ye from Yuanzhi University. In your presentation, you mentioned a lot of different topics. Actually, a lot of people are thinking about the digital trust on internet. For example, now we have a lot of deep fake and automated misinformation. So can I please ask Professor Ye to talk about this? So under such circumstances, how the government and different multi-stakeholders can implement digital trust and to really ascertain the authenticity. So let me get one thing clear. We only have 2 questions to take the question, right? Because we are running out of time, right? So 2 minutes. All right. So in terms of digital trust, I think it's actually very difficult. As you mentioned, we need the engagement of different stakeholders and multi-stakeholders. Especially now the AI-generated content actually involves a lot of misinformation or disinformation, and they have been spread around on the internet. In the past, we believe that the platform should actually have the oversight over such content. But what we are seeing right now is that the problem or the challenge is that we are unable to identify whether or not these are true or false. So we need to know who or where this content is coming from. So I think this is what the platform needs to focus on right now. But the platform now really needs to have this defensive mechanism. For example, they need to know how the content is generated and where is it from, how they can track these contents. So this is what the platform should do and what they can do. But on the user end, they should also try to elevate their digital literacy, but this has to do with the education and the society's acceptance. So I think this is something that we should do for children nowadays, because this is actually something we need to nurture when they were young. So if we can do that, we can actually have the users to have the awareness over such issues. Thank you. So I think that this is actually a suggestion from the research and academia field. Now I would like to ask Ms. Anjum. We know that GNI is actually a multi-stakeholder organization. Now, in your experience, in this model, how can you ensure effective operation? Now, you have seen experiences from different countries. So what's your suggestion how we can go about this? Thank you.
Thank you, Commissioner Wong. And this is actually what I wanted to come to before. Apologies, I have certain health complications which affect composure in unpredictable moments. But so returning to the point, GNI's multi-stakeholder model it works because of commitment of our members, but also precisely and more specifically that helps with trust building is a certain degree of confidentiality within spaces, which allows the model to operate in the first place. And now we have undergone several strategic reviews that kind of helped determine how to really convey or derive these learnings that we come across within the organization and feed them into processes. But I don't think like the value of multi-stakeholderism is established, and we like this conference is an example of that. But now the challenge that I want to kind of speak more towards, which is slightly tangential to what we have been discussing so far, but still relevant, is governments now, in our experience, are more open to engaging stakeholders, especially in the region, in this region, like in Asia, in the Asia Pacific, which traditionally has been a little more difficult to navigate compared to, let's say, Europe or the North America. So governments are opening up, but what limits engagement or what makes engagement really difficult are really simple things, such as how consultation processes are arranged. And by that, I'm referring to, let's say, the availability of translations of draft regulations, providing enough time for stakeholder feedback, because companies have resources that they can dedicate towards engagement processes, but civil society or academia in particular, independent technical communities in particular, face capacity constraints, which they're not always evident given the sort of expertise that they bring, but I think it's something that governments need to be more conscious of when they're arranging these consultations or forums to engage different stakeholder groups. And I think that is kind of, there are other sort of challenges that we run into, like who is the right person to communicate when we want to engage on a particular amendment or a subject of deliberation. So these are really rather simple sort of aspects that are often overlooked in the region, in many of the regions that I personally work on, which is the Asia Pacific and Africa. And I think we are now focusing more and more to shedding some light on how do you institutionalize these practices. I think the EU, the UK, and Australia have held really robust engagements in certain specific laws, and now other countries are like we point towards these practices in order to kind of give an example of how make it easier for stakeholders that that want to engage to actually be able to engage. And I think that in particular, when stakeholders start to feel valued, when stakeholders start to feel that they have opportunities for effectively engaging and meaningfully participating, that will eventually lead to the trust that we need in more public spaces nowadays. So thank you.
谢谢哦。那也是从很
Thank you, Ms. Andrew, for your sharing. Now, I would like to turn to Ms. Liao from Microsoft Taiwan. So we talked about the technological development and the role that the government and the industry play. So we know that Microsoft is a key player here, but now we are seeing everyone's talking about AI. So when it comes to AI's internet governance, what are the things that we need to look after, and what's the role of the government and everyone else's? Okay, thank you for your question. First of all, maybe we should look at this from a broader perspective. So if you look at the history of humanity, you will see major technological advancements that shifted or changed or transformed people's lives. And now AI, of course, is another one. So compared with the past technological development, for example, the printing technology helps the spread of information. And decades ago, the emergence of internet also reshaped our society and the world. And of course, you will see AI technology will reshape our world again, but it will happen at a faster and quicker pace. Now, Microsoft not only plays a role in internet governance, we also want to play a role in responsible AI. This is something that we have been paying a lot of attention to. And I think that it also applies to the internet as well. Responsible AI, if we look at this topic, and if you look at across the world, you will see a lot of different standards. For example, NIST, for the AI risk Dist. There's actually the definition for the activities and regulation approach. All of these things have been delineated. And we also have ISO 42001 that has been implemented. So we hope that the internet governance in Taiwan can align with the global standard. So what we are trying to do here is that when it comes to AI governance, we need to adopt a risk-based approach. So we have some suggestions that we would like to make. First of all, when you have a new technology, the governance approach may be different from the past. So we would encourage people to understand this new technology, to know how we can identify a proper way to regulate it. For example, you don't want the governance approach or mindset for internet to be reapplied to AI nowadays. Of course, we will have to put that into consideration. We don't want to have a solution for one-size-fits-all solution. So you don't want an old approach for a new technology. That is not something that can last. Also, AI is also new because we need to have a risk approach. When you have new technologies, in different scenarios, you will see different risks. That is why we need to adopt a risk-based approach. So you have to really consider the use scenario so that you will be able to identify the risk levels. So when we talk about responsible AI at Microsoft, we have 6 principles, and we are very happy to see that Taiwan has such laws and regulations that have been implemented earlier this year. So when we talked about the responsible AI, we can see that people are sharing the same ideas and philosophies. So earlier we talked about transparency. I think when it comes to transparency, it's important that we need to allow everyone know that the limits of such technology, what it can do or what it cannot do. We help the developers, the users, and our clients to know all of these. So because of that, in the world of the internet, we are very supportive of such development. We need to allow people to know the content. The users need to know that such content may not be generated by human. It may be generated by AI. So this is one thing that we will focus on. If we can do that, we can help people make informed decisions. And of course, you will see a lot of different technologies. For example, you will have watermark on certain production of contents. So actually, you will see that some traditional methods are still valid nowadays. So it may not be innovative. We just want to reintroduce some ways or measures that can actually see benefits. And also, the multi-stakeholder governance is key here because, like I said, the internet actually reflects the real world society because our life is actually involved with the internet and the AI. So the governance that we talked about here need to actually cater to all of that. It's not all about legal framework. You also need to take into account the use and also other technologies. So multi-stakeholder perspective, of course, is key here. So that's the end of my sharing. Thank you.
Thank you very much. We have actually exceeded our time. So I'd just like to ask Ms. Chen, you mentioned the challenges faced by platforms. So my question is, how do you balance the need for accountability and as well as the need for oversight so that we can ensure the security of the user on the internet? Thank you very much. We face many problems. First, the competent authority do not make a distinction between the statements made by businesses and by individuals. So from the perspective of the competent authority, it wants to remove, for instance, e-cigarettes from all platforms. So in Taiwan, businesses cannot sell this, and there cannot be advertisements on e-cigarettes. But from our association, we believe that there needs to be a clear demarcation so that different platforms will know what words to use and what words not to use. This is number one. Number two, there's no notice and takedown mechanisms in current legislations. If the competent authority found one message containing the word e-cigarette, it will fine the platform and also ask the platform to take down the message. And as a result, the businesses will receive many fines, and it will also remove all of the messages. However, in so doing, the platforms will feel that it's very difficult because there's no notice and there's just a fine directly. Therefore, many platforms want to have a notice and takedown mechanism. I believe that platforms should not be responsible solely for monitoring the content of the messages posted on its platform. So I think that there should be more communication between the government and also businesses and the platforms, because operations of platforms are not as simple as it seems. Thank you very much. Because we are behind by 15 minutes, so we do not have time for further Q&A. I would like to thank our 5 speakers for their very insightful presentations. If you have any further questions to our speakers, you're welcome to ask them during lunchtime. Thank you very much. Thank you very much. I would like to invite our speakers to remain on stage. We will take a group photo. Thank you very much.
Please remain seated and just face the camera in front and give your best smile. 3, 2, 1。摄影单，我们还要再一张吗？ Okay, one more please. 3, 2, 1. Wonderful. Thank you, thank you. Thank you very much. You may return to your seat.